Good afternoon to all the listeners of this lovely webinar. It's a pleasure on behalf of the Indo-German Chamber of Commerce. It's a pleasure to welcome you all to this knowledge session. Uh, as you may know, the DPP Act is bringing some big shifts in how we handle data in India. And while we hear of it, many of us are obviously still figuring out what it means in practice. Cyber insurance is becoming a big part of that picture, and the rules of the game are slowly being changed. So we've created this session mainly with the support of one of our key members, JP Boda Insurance and Reinsurance Brokers, and we have privileged to have Mr. Ajay Achyuta, Executive Director from the company, who will try and simplify this whole process for us, give us a little more simplistic understanding, and hopefully this will be beneficial for our members. So this is basically our attempt to create more and more ongoing engagement in terms of knowledge sessions, and we find this extremely valuable for people to kind of even listen in person live, or maybe even a recording at the end of it that will be sent to you. So definitely would love to have your feedback and hopefully do more of these in the future. So on that note, Mr. Ajay, welcome to this webinar, and I now leave the floor to you because I know you have a lot of content to cover. So I'm going to sign off here and wish you a great webinar with our members.
Thank you so much, Radhika. Very good afternoon to all the attendees. Like Radhika said, yes, the topic of today's discussion is actually extremely important and very topical. When we kind of discussed about presenting this at that point of time, the rules for the data protection were still not come through, but it has come in the full force now, and this is, like I said, a small attempt in actually kind of clearing up some of the areas of concerns on the Data Protection Act, as well as how a cyber insurance policy would probably respond to certain situations. With that, I will request IDCC to kind of,
Thank you. Thank you so much.
Yeah. So before we kind of start off on the main agenda, I just want to kind of take 2 minutes and introduce our group to you. So we are JB Boda, Insurance and Reinsurance Brokers, as Radhika mentioned. We are in our 82nd year of operation. So we started off the operations in 1943. You can move to the next slide, please. Essentially, family-run business. The founding fathers were basically in the business of stockbroking, and one of their clients actually had a requirement for, I would say, a professional indemnity insurance, for which a reinsurance had to be kind of brought into play. Unfortunately, at that point of time, there were not many reinsurers, or the market was still immature, and the reinsurance markets typically being outside of India. We had to procure the terms from Lloyd's, which is the reinsurance supermarket, I would say. So Mr. JB Boda actually kind of procured those terms from the Lloyd market, and then we got into the business of reinsurance. That's how we started our group operations in the year 1943. Next slide, please. So this is some of our milestones. Like I said, 1943 is when we started off the company. We are in our 82nd year of existence. We are the first Indian broker to be accredited in the Lloyd's market. So currently we operate from London as well. We are close to 800 plus colleagues. We manage 525 global relationships with insurers and reinsurers, because like I said, the reinsurance being one of our key area of operation. And we have close to 3,500 clients, both in insurance and in the domestic sector. Yeah, we can move to the next slide, please. In terms of our presence, you would actually find that we are dotted across the coastline of India. This is typically because we kind of also run a parallel company called the JB Boda Surveyors and Loss Assessors, who do a lot of cargo supervision. So it's essential that we have our operations in the port. But on the mainland, we have operations right from Delhi, Gurgaon, Noida, down Mumbai, Pune, Ahmedabad, Baroda, coming south, Bangalore, Mysore, Chennai, Coimbatore, Cochin, Visakhapatnam, Hyderabad, and Calcutta. So in close to 27 offices in the mainland of India, and we have 11 offices outside of India, which basically catering to the reinsurance market. London, Singapore, and Dubai are the reinsurance hubs, so we naturally have operations there. But closer home, we have operations in Colombo, Nepal, Bangladesh. We have offices in Africa as well. And so this is our span of area where we do. So 27 offices in India and 11 offices outside of India. Next slide, please. So this is the group actually kind of undertakes activities in 4 different verticals. We have the basic company, the JB Boda company, through which we extend the employee benefits services. This is basically the actuarial valuation for leave encashment, gratuity, and things of that sort. Then the next company is, of course, where I am representing JB Boda Insurance and Reinsurance Brokers. We do the entire scope of insurance advisory to insurance companies as well as organizations who need the insurance solutions. I also spoke about the insurance surveys and loss adjusters. These people come in when there is a typically large losses on fire, earthquake, flood, and then they do a assessment. Finally, we have a joint venture called Boda and Company, which is into the business of protection and indemnity club. We handle 2 agencies, which is the Steamship Insurance of London and the Protection and Indemnity Association of Luxembourg. So this kind of completes our group holding and the group companies. I thought it would be pertinent to put it across there so that you actually understand who is speaking to you. The next slide, please. Yeah, so this is what today's topic is, again kind of distributed into 2 very distinct parts actually. One is, of course, the DPDP, or the Digital Personal Data Protection Act, and the rules of India. And we are going to see how it is kind of matching up to the cyber insurance policy that is available in India as of now. So before I actually delve into the full presentation, I just want to kind of make a disclaimer. We are not a legal association, and in no way it should be construed as a legal advice. For compliance or for legal purposes, you may actually have to reach out to your respective compliance team. This is only our understanding of the DPDP Act, as well as to an extent how certain sections would be kind of covered or not covered under a cyber insurance policy. So with that, we can just start off the presentation. Next slide, please. So it's important to understand the genesis of the Protection Act. When we talk about DPDP, this is the thing we are going to use for the entire 1 hour. So it's a digital and personal data. So many organizations think as to how they would come in, that we will actually discuss in a future slide. But we are talking only about data which is digital and personal in nature. So the Information Technology Act of 2000 in India had some kind of a reference to protecting sensitive personal data, but it was not very clear, and it was never explored to its full limit actually. Even in 2008, there was some amendment to kind of define what was or an attempt to define what was a personal data, but it remained that much, and no further exploratory advances were made. Sometime in 2009, actually, the Aadhaar came into the being, and the government of India kind of issued the the Aadhaar project, so to say, and the Aadhaar cards were being issued. In 2017, actually, retired Justice Mr. Putaswamy actually kind of filed a case saying that there is not adequate protection against personal data, or there is a privacy matters relating to the Aadhaar, and a full-fledged case was actually contested in the Supreme Court. An expert committee was set up on the privacy issues, and this finally led to the Government of India releasing a draft data privacy bill sometime in 2018. That bill was introduced in the Parliament in 2019, but it was withdrawn in 2022, and a new DPDP bill was introduced in 22, which has now become an act in 2023. So, this is where the personal data protection context is actually coming into. So, after the act was promulgated, like any other act, there are rules which needs to be followed, and those rules have now, like I said in the beginning of my presentation, they have come into the being. We will quickly go into the particulars of the act. The next slide, please. Now, one of the good features of this act is that, generally these acts are very voluminous, but the DPDP Act is very succinct and to the point. It just has, 21 pages. There are, of course, 4 sections, 9 chapters. Importantly and very interestingly, there are 11 illustrations. So every time if a act's provision has to be kind of, I would say explored or application needs to be looked into, anyone could actually refer to those illustrations, and those are very clear. The general opinion when the act came was that it is industry friendly. I will also tell you why it is industry friendly, and it's felt that this would actually help the organizations to kind of implement a privacy or a data protection kind of regime into the system. This is the spirit of this act actually. Like any other act, like I said, it must be followed by rules, and we have these rules which were kind of released on the 13th of November 2025. Next slide, please. So I will go chapter wise. I mean, will not go in detail because that's a different kind of session will be required for the entire analysis of the act. But these are some of the very important provisions. The first chapter details about the definition. So we have this entities or I would say bodies which need to be put in place. A consent manager. So just to give you an example, some of the websites you would have visited, maybe in the EU or other places, there would be a consent seeking mechanism. You will have to click before you can proceed further onto the website. It's a consent, kind of requesting cookies or something like that, which they kind of put in place. So a consent manager will be kind of registered. So there is a board which is the data protection board which will come into the play, and they will kind of appoint, or the consent managers would actually have to be appointed with them. When we talk of a consent manager, we are actually talking about a company or a firm or an organization which would handle the entire consent process for for the organization. So the consent manager, as has been mentioned here, is the single point of contact for any data principal. So who is a data principal now? That comes a little later, but I will let you know. You and I as individuals would be the data principal, and any organization who collects our data, let's say a bank or any other organization, actually would be called a data fiduciary. So a data fiduciary is someone who will determine the means and purpose of processing data. So a bank collecting my data will be a data fiduciary. I will be a data principal, but I will have to go through a consent manager before the data can be processed or acquired by the data fiduciary. You have a data processor who processes data on behalf of it. So a data fiduciary, like a bank or any other organization, can engage another organization called a data processor, who is also defined under the Act. And the data actually flows from the fiduciary to the processor for the specific purpose of processing the data. There is also a requirement that a data protection officer needs to be appointed, but this is only in case of somebody called a significant data fiduciary. Now, a significant data fiduciary is someone who would be appointed, by the Data Protection Board or the Government of India, who they deem fit need to be called as a significant data fiduciary. So our assessment is like anyone who uses voluminous data or sensitive data, establishments, having relationship with, let's say, with the authorities, defense, police, these would definitely be significant data fiduciary. Also would be banks, maybe insurance company where the health insurance records are being placed. So these entities will also may fall under their significant data fiduciary. The rules have to still come out, and when you are kind of defined as a significant data fiduciary, then it is necessary that you also have a separate data protection officer. Like I said, they will be kind of notified by the government of India. One important aspect is on the data transfer between India and outside of India. I have a later slide where the DPDP compares itself with the GDPR, which some of you would be aware is the general data protection regulation applicable in the EU. And there is significant difference between how data can be transferred outside a particular jurisdiction. As of now, the DPDP allows you to transfer the data from within India to outside. So that is what the act says. But yes, I mean, at any point of time, the board or the government could actually come in and say that certain information will have to remain within the borders of the country. I already mentioned about the digital data. So it is the digital data, digital personal data, which should be, which is considered within the ambit of this act. You can move to the next slide, please. Yeah, so as an organization, what would be the obligations of a data fiduciary? There are a lot of obligations, but you need to take consent of the data principal, that is of the individual. Language allowed is English, or these are typical act kind of a reading. If you read any act, this would be the thing. The most important thing in this obligation is, which is actually a game changer, is the one highlighted, which says that in case of a breach of data, the data fiduciary has to report it to board and each affected data principal, which means if there is a data breach, let's say at a bank, then the bank has a responsibility. Till now, India didn't have a breach reporting or a notification reporting kind of a law, but it's going to change from the time the rules are going to be implemented. Every entity who collects data or is a data fiduciary, and if there is a breach, if they see a breach, then they have to report it not only to the board, they have to reach out to the individual affected data principal. So this, as you would also later see, would create a lot of liability, and there could be compensations payable by the organizations to the data principals. There is also a requirement to be data to be erased or data to be forgotten. That's as we say. So the data processor will be actually kind of responsible for that. We can move to the next slide, please. What are the rights and duties of data principal? Data principal, like I said, is an individual. So the individual has right to access information, processing rights, right to correction and updating and erasure of data. I kind of mentioned that it is industry friendly. So there is also a provision that if an individual kind of files a false or frivolous grievance, then the individual can also be fined. The board has the power to fine individuals for false and frivolous complaints against a data fiduciary or an organization who is holding his or her data. We can move to the next slide. So this I kind of already mentioned. This comes under special provisions, processing of personal data outside India. Right now it is allowed, but at any point of time, the government of India can come with restrictive rules and say that data cannot be shared. So there are certain exemptions also. If there are mergers and acquisitions, processing of data by a court, and if there are certain legal rights, then financial information for persons in default. So these are some of the exemptions where the data cannot be, or rather the data can be kind of provided outside of India as well. Finally, the government can also notify certain data fiduciaries, that is organizations exempt from this act. I mean, per se, a blanket exemption can be given to certain organizations if they can prove that they have such business of transferring data outside of India. We can just move to the next slide, please. So there will be a Data Protection Board of India, which will come into the being shortly. The term is for 2 years, and yeah, so the compensation qualification, and there are certain norms and regulations as to who can be appointed as chairperson and the members of the Data Protection Board. This is just the chapter 5, so I thought I will put it out there. We can move to the next slide. So what are the functions and powers of the board? Again, very important thing. Like I said, there was no breach notification requirement for entities, till now, barring few, let's say, listed companies or something like that. But now anyone who would hold a personal data, and if there is a breach, they have to kind of immediately reach out to the board and then report that notification. And the board will also then ask them to report it to the individuals, or what we call the data principals in this context, to be reported of that breach. So the board has the same powers as a civil court. And as I mentioned, if the complaint is false or frivolous, board may issue warning or even impose costs to, on the data principals. Yeah, the next slide, please. Like any other board which operates, there is a appeal and alternate dispute resolution mechanism also available. So the appellate authority for the data protection board is actually the Telecom Regulatory Authority of India. So any data fiduciary who is unhappy with a particular decision of the board can approach the Telecom Regulatory Authority on an appeal actually. But mostly on the reading of the act, like I said, because it is industry friendly, there is a lot of scope for mediation and to kind of even make amends. I mean, if there is a breach or something like that, rather than taking a very strict point of view, the reading of the act is that the board is kind of trying to encourage mediations or make amends or improve the systems if at all there is data breach at a data fiduciary's location. Can we go to the next slide, please? Important section, penalties and adjudication. So the board can impose penalties if there is a breach, and the penalties would be there is a schedule of penalty which I will come to later, but the board can decide what could be the breach and what commensurate penalties could also be imposed by them. So there are a couple of like I said, the illustration also is very clear. So any person who has realized gain or avoided loss as a result of the breach. So this is an important consideration. Somebody, some entity has to make a profit out of the data breach. A simple data breach may not qualify for a penalty and adjudication. So there is a lot of leeway within the act to kind of for the board to consider. So this is another reason I said that these are industry friendly. The impact of the imposition of the penalty on the fiduciary is also taken into consideration. As you would see, some of those penalty values are pretty high, and imposing them would probably make a data fiduciary even bankrupt. So the imposition of a particular is, I mean, the impact of what would be the penalty on that is also studied before the board would actually impose a penalty. So here the important thing again is whatever would be the penalty, that is actually not going to the person who has suffered a data breach, but it goes to the Consolidated Fund of India. So there are ramifications or there are implications of this. Even though the penalty would be paid to the Consolidated Fund of India, we kind of presume that once a breach notification is done and a penalty is being imposed, that would open up a lot of civil cases or compensation cases, where the individuals may approach even the civil court or someone saying that, the data fiduciary, there is a breach and there has been a penalty imposed. So compensation could be payable to the data principals, but that is outside the ambit of this act. The act per se is not talking about the compensation payable, but we are kind of looking at it at this way that if there are penalty imposed and notifications are being made public, then the principal would probably reach out to civil courts, contesting a civil wrong or a tort, and there could be liability kind of getting assigned to the data fiduciaries. Next slide, please. The final chapter is on miscellaneous. So these are some provisions which is normally always there. No suit against the sovereign, country, and all actions are taken in good faith is what it would be believed. And there are powers that Government of India can block the access to data fiduciary intermediary resources. Rules and notifications to be issued, they have been issued, and there is a power to amend schedule, which is the same actually for any of the acts. So another act in the Parliament could actually have these acts amended as well. So these are the 9 chapters which I was talking about. you could actually download the act and then go through it. It is quite interesting, and it is not a very kind of a normal act which kind of puts you to sleep, but it's quite interesting with the illustrations as well. Can we go to the next slide, please? So these are the schedule of penalties I mentioned. The top one is breach in obligation of data fiduciary to prevent if there is a data breach and there is an obligation of the data fiduciary. The amount is actually 250 crores. Like I said, these are the maximum limit, and it is not, even though these values look very high, we have seen cases of, maybe large organizations actually paying up this thing. Google, for example, had to pay something in Ireland, and similarly, Microsoft also paid some large amounts as penalties in following the data breach or certain other, breach of certain laws. So that is the reason these are being kind of put a breach in obligation of notice of a data breach. So they are taking it very seriously. The moment there is a data breach and an organization comes to know about it, there is an absolute obligation of noticing or notifying it to the board and to the principals. There are quite strict obligations relating to the children. That's why again this amount is very high. And significant data fiduciary as well. Organizations which are going to be nominated as significant data fiduciary, they will also have sufficient breach and I would say penalties in breach of their obligations. The fifth is the most interesting item. Like I said, if the board or if the protection board is actually kind of I would say sees that there is an individual who has filed a frivolous complaint, even for that there is a fine which is around 10,000 rupees. And finally, breach of other provisions, you have 50 crores as the limit. Just to kind of give you a little insight, I have put on the the link at the bottom of this slide. You can actually visit this site, the enforcementtracker.com, and you can actually see what are the typical fines being imposed in contravention of the GDPR. So that that's a good indicator of what would be. So there the fines are even starting, let's say, from even 1,000 euros and going up to millions of euros. But how the EU Protection Board actually imposes fines and the reasoning can give a good insight as to what could probably be coming in India as well. So please feel free to reach out to that website and then understand what could be some of the breaches. And we can go to the next slide, please. This is what I was talking about. Currently the most comparable data protection law is the GDPR, and some of you would be aware, being a German-based organization, you would be aware of the GDPR. So this is a simple comparison because it could be quite confusing. For example, data principal in India is called a data subject in GDPR. A data fiduciary is a data controller. Data processor is the same. There are obligations, and what is the definition of a child, for example. So this again, you would find it helpful. And like I said, the penalty is, while we have 250 crores, they have up to 20 million or 4% of the global turnover. This is what they have allowed. Importantly, cross-border data transfer allowed unless restricted by government. And under the GDPR, it is much restrictive. It's not a free transfer. You have to show sufficient safeguard. The country where the data is being exported needs to kind of show sufficient safeguards, and only then the GDPR allows data to be transferred. Can we go to the next slide, please? So yes, like I said at the beginning of the slide, I had this deck prepared when the rules were not notified, but this is a stop press kind of a statement. So rules have been issued. So the appointment of various officers will come into the being. So what are we saying is naturally, anyone who holds personal data, they would be the primary target. E-commerce, these are the people. So how does it affect, let's say, a manufacturing organization? So if you were to have website sales, or if you have other engagements where a personal data is being processed, then you could fall within the ambit of the DPDP Act, and then you would need to watch out actually for where you are storing the data, and if possible exposure for data breach could be there. One thing is for sure, this is again being contested whenever organizations hold the employees' data. So that is more or less, what you call a given fact now, that the employee data will be considered as personal data. So, if you have your HR departments and where you store data, and if there is a data breach, then the employees could be well within their right to kind of, I mean, you will have to go through the notification and, penalties, and then there could be even, cases where employees may decide to file a suit against for the leak of personal data. So that is something which would affect the, manufacturing industries. I just gave a key rule implementation timeline. So the final timeline is 18 months from 13th November. There are certain sections of the rule which needs to be implemented by the 2020 1 year, and then the balance would be implemented or would come into the existence by the May of 2027, which is 18 months from the date of notification. So that is what I had for the data protection or the Digital Personal Data Protection Act and rules, the various sections and the implications of what could happen during a data breach. Can we move to the next slide? Yeah, so I will now try to kind of twin it and then bring the play of cyber insurance, or what cyber insurance could possibly do to kind of obviate some of the exposures which you may have under the DPDP Act and rules. We can go to the next slide. Here again, I'm kind of setting the context of cyber security and the need for a cyber insurance. Maybe a little bit about the history. Typical coverage. It's important to know because the cyber insurance per se evolved as a response to something called the third-party liability. So a data breach was the primary requirement of an insurance, and since we are talking about DPDP and breach and all, I thought it deemed fit that we kind of explore the full context of the cyber security and the cyber insurance, and then kind of dovetail it to the common agenda that we have at hand. The next slide, please. This is a simple concept actually of cybersecurity. Everyone understands. I mean, it's quite cliched. We say that data is the new oil on the information which is required to run on the information highway. There are increasingly security and privacy issues. The latest, of course, is the DPDP. There is a widespread use of information technology and the internet. Very, increasing regulatory oversights. There are already, SEBI, RBI, or the IRDA comes out with their own cyber rules and regulations, and then now we have a full-fledged the Data Protection Board as well. So these are some of the reasons why cybersecurity is so important. And lastly, we also come to know of the involvement of the state actors or sponsors. So it's not only that organizations or individuals are kind of deploying or hacking your systems, but we are quite aware that there are state-sponsored actors who are kind of front-ending the cyber hacks. Next slide, please. Yeah, so given that we understand what a cybersecurity requirement is, we will just go through what is a need for a cyber insurance. So data breach can happen despite the best of cybersecurity. So this is an often contested piece that most organizations who have a CISO or a Chief Information Security Officer, they would typically say that let us kind of invest in the security measures rather than buying an insurance. But what we say is, despite the best security measure, it's like having the best firefighting system in your factory. You may have hydrant systems, the sprinklers, smoke alarms, but despite all that, there is a fire, and then you need insurance as well. So this is something which we say, despite your best cyber security, you will still need kind of the cyber insurance. Zero-day vulnerabilities, patching up takes time. So these are some of the other things which probably kind of need the cyber insurance to be in place. Few other things I have put up, not very important, legacy systems, and I also spoke about compensation following third-party data breach. So these are the things which typically, make an organization require a cyber insurance. We can go to the next slide. So just a little bit of history. I mean, people who have dealt with insurance, it's normally believed that the cyber insurance has kind of, come in from the engineering insurance. I mean, the engineering insurance typically had the project insurances, and then they had machinery breakdown. There was also a section on something called the electronic equipment insurance, which used to insure the chip-based or the computers and other electronic equipments. And these had two separate sections. One was, you could actually have an external data media also insured, and you could also insure the increased cost of working if your data actually fails or your computer actually kind of, breaks down. So this was one aspect which was picked up from the, electronic equipment insurance. The second was, with the booming software industry, software is typically, delivered by way of a contract. So, the technology errors and omission insurance came into play. When you engage somebody to develop a software for you, there is a contract between both of you. And if the software developer does not kind of develop the product to your liking, then you could always kind of, claim for compensation by way of a breach of contract. So this was the other aspect which was, coming into play. And then there are the normal, commercial general liability policies or the commercial crime policies, which had all instances of cyber, exposures. And, having all these policies was little kind of cumbersome to attend to each of those exposures. And that is the reason that cyber insurance actually came into the play. We can go to the next slide. So in a nutshell, this is what a cyber insurance covers. You could actually have a security breach liability, security breach expenses, extortion. Then you could have ransomware, website publishing liability, PR expenses, loss of business income. So just to suffice to say that, there are two separate aspects to it. One is called the first party liability, and the second is the third party liability. So the first party is where the organization suffers, like a ransomware, for example. When your systems are shut down and you need to engage a forensic, team to kind of engage with the people who are behind that ransomware, you may sometimes need to pay up. So these are all the first party expenses. And the second part, the third party, is where there's a data breach. And then, like I said, in the DPDP Act, for example, you could actually be liable after you notify to the board and to the principals, and by paying a penalty, you kind of admit liability of data breach, and that could give rise to third-party liabilities. The principals could file a case, and then you could be responsible to pay compensation. So these are the two broad areas of a cyber insurance. We can go to the next slide, please. Like I said, first-party exposures and third-party exposures, detailing it a little more. Loss or damage to data information, breach of compliance, privacy, business loss. So what happens is, in a typical ransomware situation, not only does your system shut down, but if it is a revenue generating activity you are engaged in, typically to pull back from the ransomware attack, you would need maybe a week or a 10 days time. And by that time, your revenues have actually dropped down because of that. So the policy also covers loss of profit or loss of revenue. And this is again, like, because it's an organization's loss, it's called a first party loss and is payable under the what you call cyber insurance policy. The third party liability I have already kind of, dwelt upon. It is basically data breach, and then third parties are actually kind of, suing you for a compensation. Next slide, please. These are typically some of the examples which I have given. Some of you may already be aware. So, breach notification costs, or, distributed denial of system, DDoS, as we say, multimedia liability. If there is a copyright infringement, let's say you have a website and you're using a music which has not been, kind of copyrighted properly, then the original music owner could actually file a suit against you. These would all constitute a third-party claim, while first-party claim would be business interruption, extortion. Somebody could actually get into your system and then hold that data and then say that unless you pay up, we are going to kind of, maybe even exfiltrate the data. So diverted funds also kind of see kind of make a appearance here. These are where you would have all seen the newspapers where organizations, the CEO is traveling somewhere, and then it's purportedly a mail from him saying that you transfer 5 million of euros to X account, and then you find that the X was actually a con. So the business email compromise, BEC, or invoice manipulations, as we call, these are all first-party claims which are available under the cyber insurance policy. Yeah, we can go to the next slide, please. There are certain add-on covers. I will not take much time, but the first one is the payment card industry, where fines could be imposed upon you by MasterCard or Visa for failure to kind of safeguard the data. There are emergency costs. Important thing is the software industry works in a particular way. So there are also expenses which you can, for example, again, a ransomware or a data breach attack, and you could actually engage some of those specialists, or what we call the white hat people who do a bug bounty program, and there are organizations we engage them to find a bug in the system, and then they pay up. So these are some of the things which are covered under a cyber insurance policy. We can go to the next slide, please. Yeah, so what exactly happens after a cyber attack? So this is the most important thing. If you actually have a policy, then most of the insurance companies would give you a 24/7 hotline. So there is a team called the forensic team, a designated forensic team, which will be allotted into the policy, and you would need to reach out to them first. And basically, they would actually get into the action. It could be physical or remotely. They will get into the system, and then they try to find out, what has happened. There is also a concept of the golden hour within these breaches, which is basically within the first 6 to 8 hours is the most important or the critical, where you necessarily need to reach out to the forensic team, and they could actually do many things to kind of mitigate or put right the system or put right the situation. You could also engage a public relation team or certain mitigating teams. Actually, the PR team actually would come in and let you know if there could be substantial what you call reputational loss. So that is under cover which is available under a cyber insurance policy, because the reputation of the firm is going to be going under. So what to say and what kind of statements to be released, that also you could engage a PR, which will be covered under the policy. Yeah, we can go to the next slide, please. So I'm just kind of detailing few major cyber attacks which has happened in manufacturing industry. In fact, this first of the recorded, I would say, cyber attacks, happened in a manufacturing unit. Some of you who are in the manufacturing segment would be aware of this. So Stuxnet was a worm. I mean, so this actually attack was again purportedly, masterminded by US and the Israeli, agents. This was kind of, I should say, used to attack the Natanz facility, which is the Iranian nuclear facility. What they did was they embedded this worm onto a USB, and these USBs were kind of, sent across different part of the world. So now the worm actually, activates itself when it particularly sees a particular, what you call a PLC, a program logic controller. And these PLCs were being used in a centrifuge in the Natanz facility. And as soon as they kind of, matched up this particular PLCs, then the worm activated itself, and then they made the centrifuge defunct. So it was a long time before the Iranians could actually find it, because the centrifuges were wearing themselves out. They were rotating at high speed, and then they were wearing themselves off. So that was one of the first recorded cyber attack, I would say. We have then in Saudi Aramco also we had this attack which disrupted the supply chain, and they had to kind of bring down their systems, go into a manual mode, and then rectify the position. So these are some of the plant-based cyber attacks. We can go to the next slide. So next one I'm speaking of is again an important one. This is the target data breach which happened in 2013. Why it is important is it underscores the importance of having a robust secure system even at your vendor's place. In this particular case, even though Target themselves had a highly evolved cybersecurity system, they were allowing their vendors. In fact, an HVAC contractor actually who was doing the air conditioning repair, he was allowed to kind of close out his job by logging into the Target's main server, and the intruder actually came through the vendor's system, and then they targeted what you call the point of sale system of Target. Target is actually a large, a mall or a departmental store, and they had huge loss of around $291 million actually. So what we are trying to do, say here is cybersecurity and the data breach. Sometimes your security system will be very robust, but if your vendor has not so secure, or if your allow vendors or if your due diligence has not been done, then you can still succumb to certain large data breaches. We can go to the next slide. So this is another data breach, where again, if you see, the complaint was initially hacked via consumer complaint web portal. So they had a web portal where you could lodge a complaint, and then there was some vulnerabilities in that portal at that point. So the attacker, posing as a genuine complainant, actually could make way into the main servers of Equifax and create a lot of data breach and system disruptions. So this all kind of to let you know how the examples of data breach which has happened both in manufacturing and in software industries. Like I said, we won't know actually where the system is I should say vulnerable, and there is a constant need to be fully aware of our systems and even our partners or vendor system as well. Yeah, next slide please. Yeah, so this is my last slide, by the way. So the effect of pandemic actually kind of amplified the requirement of cybersecurity. All of you are aware during the pandemic, the IT security policy was a little bit diluted. People were working from offices, which naturally means that you are not, maybe you're logging in through your home routers, and which is not as secure as what you would have in the office thing. So these are data from stolen laptops. This is again a very serious issue, and you could actually lose data from there. Employees returning back to work with compromised asset. Yes, I mean, if you have been working in the home system and WFH, there could already be a virus or a malware sitting in your system, and then you kind of come, and when you log on to the main server or the main organization system, this was also creating extra exposures. And finally, yeah, online classes also, we know a lot of issues have happened due to the increased exposures and the exposure in relation to children being exposed for these data breaches. So in a nutshell, yes, the pandemic has kind of highlighted the requirement of cybersecurity, and so one way of actually kind of addressing the cybersecurity is actually availing the cyber insurance. That is pretty much what I had. I know I have probably taken up a little more time, but happy to take questions at this point of time. Nivida, are there any questions? I'm unable to see.
Yes, we do have a question. The first question is, nowadays many cyber attacks are happening. So just a second. Just a second. Nowadays many cyber attacks are happening. So if data breach happens, then would this act be applicable?
Yes, it would be. So, like I said, we need to understand. I probably think that the question is asked being in reference to the cyber attacks on individuals. We see a lot of news coming in that individuals have been pawned. There is something called the social engineering, something of that sort. So uh, so those will not be a part of the act because those are attacks against the individuals. The DPDP Act is specifically against companies who hold the personal data of individuals. So, like I said, the organizations will be in this context called a data fiduciary. The person who is giving the information, like I said, the bank is a data fiduciary. If I am holding an account, I am a data principal. And if there is a data breach at the bank's place, my personal data, my date of birth, my credit card, if these are being kind of hacked, then I can probably go for a redressal against the bank for resolution.
Okay, thank you so much.
Yeah.
The next question is, how about banks holding primary data?
Yeah, so this is what I just said. All the banks, in fact, what we assume will be called as a significant data fiduciary. So there would be an enhanced applicability of the rules and acts against the banks that we will see in some time. So they will have to appoint a data protection officer. They will have to be extremely careful. They will have to report the breaches. So like I said, if my account is breached or someone says that, data is out there in the open, then the bank will have to notify to the board, notify to individual account holders, and pay penalties, and then compensation will also may come in.
Thank you. The next question is, which companies offer cyber insurance products?
Oh, okay, so most of the Indian insurance companies are offering. In fact, all the public sector companies, New India, Oriental, National, and the private sector companies. You have Bajaj Allianz, Tata AG, SGFC, Ergo, IFCO Tokyo. All these companies, most of the companies, out of the 35 odd general insurance companies, at least 10 to 15 offer cyber insurance policies.
All right. What are the risks and measures to be taken by data processors, especially in case of outsourced functions?
Yeah, so the data processor is also getting defined under the what you call the act, which means that they are also going to be equally liable for the breach at their end. So the data fiduciary is going to engage a data processor or an outsource entity. But the board, in its own wisdom, may decide to fine or impose penalties both on the processor and also on the data fiduciary. So it will all depend on what type of contract is the data fiduciary or the primary organization is having with the outsourcer, or what, as we mentioned, is the data processor. But it would be good to kind of, if you are a data processor, it will be very good to have a separate insurance policy in your own name. It's quite possible that you as a data processor might be processing data from multiple data fiduciaries. So, even if a data fiduciary is covered under a particular section, some other data fiduciaries data, if it is, if you're handling, you may handle data of multiple data fiduciaries. Then as a data processor, it would be kind of, important that you have your own policies in place.
All right. Has this act been already enacted? How is this
Yes.
act going to work along IT Act?
So that is what I said. The IT Act was the Information Technology Act was promulgated in 2000, but there have been few cases, where few of the penalties or compensations were payable. The important thing is the adjudicating authority within the IT Act, was probably, or is the IAS officer of that particular location. So he was to adjudicate, there was no separate board or, any other code which was kind of formed to kind of adjudicate those kind of breaches. So that is why, even though 25 years have passed, we don't see much experience in Information Technology 2000 Act's provisions or penalties. But it is all going to change. The DPDP Act 2023, it was promulgated. The rules have come in, and like I said, within a timeline of 18 months, it is going to be fully implemented.
All right. How does cyber insurance help in case of social engineer attacks? For example, an improper child exposures for a school.
Okay, so like I said, if it is improper exposure, again now, what is going to happen? There is a whole different section of children privacy, and like I said, it is going to be extremely important. The fines, as you would have seen in my earlier slide, they are at a different level. So children privacy is extremely important. There are modalities of even obtaining a consent of a child. So the legal guardian or the parent actually gives the consent, because a child will not be able to give his or own consent. And like I said, when an improper exposure happens, if there is, or let us say if there is a data breach, then there could be penalties imposed by the board. It would all depend on what kind of exposures have happened. In fact, incidentally, the website I mentioned actually, where the GDPR fines are mentioned, you will find substantial number of cases where filming has been done without consent and then posted onto social media and things of that sort. So those will come into play. There is definitely an exposure. People would need to, schools or other educational institutions will necessarily need to revamp their existing cyber security positions to see that extra care is taken and breaches don't happen.
All right. How an organization should be ready for implying this act?
Yeah, so you would, like I said, you may necessarily need to reach out to your legal team to understand the full implication, because I gave only a capsule of it, and mine was more a response of the DPDP and how a cyber insurance policy could possibly kind of protect against certain exposures. But there would be other aspects too of the act also, which may not be which a cyber insurance policy may not be able to kind of respond to. Those would be best addressed by a privacy advocate or a privacy lawyer or a privacy compliance team. You could actually kind of get certain certifications and maturity levels are there, so you could actually attain those and then be in compliance of the act.
Or can we claim for compensation for a data breach or financial loss from a stolen device, say a laptop, assuming we manage to prove that the loss was from that particular device?
So, okay, I'm not sure I got the question fully right, but then I'm assuming that data is stolen from a laptop and then it is being used somewhere else. Yes, so it's like I said, if I hold, so this is a typical exposure which is covered under the cyber insurance policy. If I hold, a data and that is stolen by someone, the examples which I mentioned, here also, some of the cases, the data was, for example, the target or the Equifax cases are actually the data of the customers or, which was stolen from the system of the principal and, being used for other purposes. Credit card information is being routinely used. If you go on the dark web or something, you could find that, the stolen credit card information is kind of available for sale. So if it is proved that this data was stolen from a particular organization, then yes, you can claim for compensation from the government.
Right. The next question is, with regards to penalties, there is a condition for 250 crore penalty if an organization fails to prevent data breach. What does this mean? Is it insufficient controls? If yes, does that mean that the ISO certifications some companies hold will act against them if a breach happens regardless?
So this is, like I said, the act has just come into play. And like I said, the primary reading of the Act, kind of provides some solace that it is, like I said, a little industry friendly. So we will have to see how the board actually kind of, looks at these breaches. Like I said, I already mentioned about the fact that if a particular, let's say a 250 crore penalty is being imposed on an organization, the board needs to necessarily see what would be the impact of that. So when they say impact, it means that, some small organization will not be able to bear that. These limits have been put with the ultimate aim of, I would assume, larger organizations. Like I said, Google was fined some, close to 20 million or whatever that amount was under the GDP Act. So because there is not a higher limit, the board didn't want to limit itself to a lower amount. I mean, this is probably the spirit of actually having a 250 crore penalty. In practical sense, I don't want to hazard a guess, but it is very highly unlikely that a small breach would actually lead to a 250 crore. It will again depend on the wisdom and the judgment of the board to impose what kind of penalty after seeing into all the aspects of the case.
All right, thank you so much. The next question is, how do you see change in the cyber insurance premium with the operationalization of the DPDPA rules?
Yes, this is what I said. I mean, in terms of the insurance parlance, we talk about soft and hard markets. Soft market is when the rates are actually low, but hard market is when they are kind of going to go up. Again, I'm reiterating the fact that the Act is actually, Act doesn't have a provision for a compensation, if you ask me. It just has provision for penalty and for breach notifications. But these two aspects combined is going to open the floodgates of, civil suits and compensatory regime, which will come into the case. So naturally, insurance companies are kind of gearing it up. They will, of course, look for some time. Frankly speaking, this would be the right time if you haven't purchased the cyber insurance policy to go for it now, because maybe in a year's time, actually, when the exposures and the examples come through, the loss ratios, which is the basis of any insurance premium, they are going to go up on account of the implementation of the DPDP Act. And, then there could be higher premiums to be paid to purchase a policy.
All right. Or for organization processing highly sensitive health and genetic data, how should we assess whether cyber insurance policies fully cover breaches involving biological samples?
Okay, this is a very technical question, because any information, for that matter, biological or otherwise, if you are holding, like I said, I mean, if you are talking in terms of the context, again, I would come back to the basics. We are talking of a digital data and a personal data, and health data is kind of personal, and there are already rules, the HIPAA rules or something which kind of govern what should be protected. Even India has certain health protection data which is going to come through, and they are going to be highlighted in the coming days. But like I said, in any case, the breaches associated with it. I mean, so the important thing to answer here is, will a cyber insurance policy kind of respond to a particular penalty in case of a breach? Now, that again is a debatable question. Insurance company, we have other policies also where fines and penalties are paid, but a lot of things depend on whether a particular fine and penalty is payable or not. The underlying principle is that if a fine and penalty is insurable, then the insurance company would make that payment. That happens in few cases only. I mean, there are only few jurisdictions where a fine or penalty could be made insurable. So that being the case, we are really not sure as to the insurance companies will respond to a particular fine under the DPDP Act or not.
Okay. How can organizations ensure that their employees' data is safe in case they share it with banks or other third parties?
Again, so employees sharing data with the bank. So that's a personal data. So if I share my bank account data with the bank, it's a personal data. So then the organization may not come into the picture. But if it is as an organization, you are sharing the organization's data with the bank, then it again will be even though we have instances where banks or like I said, the business email compromise. Wrongful fund transfers have happened. So those could be a part of the cyber insurance policy, but uh, for the specific purpose of the act, the data breach is only considered if a personal data is being breached. So, organizations' bank data being breached, while may not be qualified under the DPDP Act, would qualify for a cyber insurance response.
Okay. The next question is, what measures must the HR personnel department implement to ensure that they are compliant under DPDP Act?
So it's the same actually, HR or otherwise. If you are an organization who is kind of holding personal data, like I said, manufacturing industries could have web sales, or there could be interactions. You could actually have a simple example is actually onboarding a vendor who is an individual, let's say a plumber, or in the example I mentioned, a air conditioner vendor, electrician. These are all personal data which the organization is going to store in their system. So along with the HR data, which is extremely sensitive because there could be health data also. We typically see that the HR department actually stores the information on the health insurance as well. So like any other personal data, the HR data or the employees data also needs to be put in a very secure vault, and care should be taken that it is not breached. That is what I would say. Otherwise, you have exposures under the DPDP Act, which was hitherto not there.
Okay. As an insurance broker, what responsibilities do we have as a data fiduciary under DPDP Act? On the same line, does the policyholder have the right to withdraw consent after issuing the policy? What happens then?
Yeah, so the withdrawal and the right to forget are important aspects of the DPDP provision. Again, as individuals, like I'm saying, so somebody, let's say, who purchases a medical insurance policy and gives the data onto a website, and the insurance company holds that data, and there would of course be a consent to first process the data, the age and the health details. But if the insured decides not to go ahead with the policy, then yes, the consent can be withdrawn, and there are what you call adjutant laws and acts which kind of decide how the erasure of the data should happen under the DPDP provisions.
All right. Okay. But now keeping the time constraint in mind, we will now wrap up the session. But in case any of you have any more questions, please feel free to write to us, and we'll make sure that we pass on your queries to Mr. Achyuta and have it answered. And now, on behalf of the Indo-German Chamber of Commerce, we would like to express our heartfelt gratitude to Mr. Achyuta for his valuable contribution to the webinar. It was an honor and privilege to have JB Boda as a partner, and your support was instrumental in making this webinar a success. I would also like to extend our thanks to all the participants who attended the webinar. We hope that you found the discussion insightful and valuable. And we would like to inform you that the recording of the webinar will be uploaded on our IGCC website, so that those who were unable to attend can also benefit from the knowledge and insights shared during the webinar. And once again, thank you for your support, and we look forward to interacting with all of you again in the future. Thank you so much.
Thank you, Sana and IGCC. The pleasure was all ours. Thank you so much. Good evening.